On March 10th, the Bar Council of India issued a set of rules that will allow foreign lawyers and foreign law firms to practice law in India. The Bar Council of India rules for registration and regulations of foreign lawyers and foreign law firms in India 2022 permits foreign lawyers to practice law in non-litigious matters in areas of foreign law, international law, and in international arbitration matters in India. The rules define a foreign lawyer as a person, including a law firm, company, or corporation, that is entitled to practice law in foreign country. A registered foreign lawyer can practice law in India solely in non-litigious matters, and they are not permitted to appear before any courts, tribunals, or other statutory or regulatory authorities. Foreign lawyers and law firms are engaged in transactional work or corporate work, such as joint ventures, mergers, acquisitions, intellectual property matters, drafting of contract, and other related matters on reciprocal basis. The rules provide for registration, renewal, cancellation of registration, and disciplinary action for misconduct. The registration process for foreign lawyers requires registration fee and certain required documents. The BCI will be final authority in registration, cancellation of registration, and its renewal. The rules were issued to keep up with the growth in international legal work sphere and the globalization of legal practice, which necessitates the growth for legal profession and practices in India. The Indian advocates will be allowed to practice in the jurisdiction of foreign lawyer. There have been reactions from both the sides, for and against the decision. The rule have been welcomed by the legal industry as it opens up the Indian market to foreign law firms and lawyers, which will lead to an increase in investment in India. On the other hand, some Indian lawyers and law firms are opposing the decision, stating that it will result in increased competition from foreign firms, which will harm the local firms. This decision to allow foreign lawyers and law firms to practice law in India has been met with criticism from Society of Indian Law Firms, SILF. According to SILF, the BCI rules for registration and regulation of foreign lawyers and foreign law firms in India are flawed and discriminatory towards Indian lawyers and law firms. Among the issues highlighted by SILF are the lack of conformity with Supreme Court judgment, the absence of phased approach to liberalization, and discriminatory treatment of Indian and foreign lawyers, a deficiency in understanding reciprocity, and absence in eligibility criteria for registration of foreign lawyers and firms. SILF has urged BCI to consult with stakeholders on domestic reforms before allowing foreign lawyers and firms to practice in India, and to suspend the implementation of rules until the consultation is complete. ILAJ, which stands for All India Lawyers Association for Justice, is against the decision of Bar Council of India to allow foreign lawyers and law firms to practice in India because they believe that the decision is a misplaced priority. ILAJ has highlighted that nearly 80% of advocates in high courts with up to 2 years of practice experience earn only between 5 to 15,000 monthly, which is very low income. In districts, the pay is even less, and women advocates and advocates from Dalit, Adivasi, and other socially disadvantaged sections face lack of opportunities and discrimination. ILAJ believes that the entry of foreign lawyers and law firms will only increase the competition in an already oversaturated market, making it harder for young Indian lawyers to make a living. In Bar Council of India versus A.K. Balaji, the Supreme Court of India ruled that foreign law firms or foreign lawyers cannot practice in India, either on permanent basis or in fly-in fly-out basis. The court held that allowing foreign lawyers to practice in India would be a violation of Advocate Act, which governs legal professions in India. The Bar Council of India argued that allowing foreign law firms or lawyers to practice in India would be against the interests of Indian lawyers and law firms and would lead to dilution of professional standards. The court agreed with the argument and held that the regulatory mechanism governing foreign lawyers and law firms was not yet placed in India, and allowing them to practice in India without any regulation would not be in interest of Indian legal profession. The court also observed that foreign lawyers and law firms could, however, advise clients in India on matters relating to foreign law and international legal issues on a fly-in and fly-out basis. This means that foreign lawyers can visit India for a short period of time, advise clients on their foreign legal matters, but cannot practice in Indian law or appear before Indian courts. This decision has raised several legal questions and concerns, amongst which are: does the BCI have the authority to make rules regarding registration and regulation of foreign lawyers and law firms in India without domestic consultation? Does the BCI's decision to allow foreign lawyers and law firms to practice in India violate Supreme Court's previous ruling in Bar Council of India versus A.K. Balaji? Should the opening up of legal market in India be done in a phased manner, starting with regulatory reforms of Indian legal profession? Should the opening of legal market in India be done in a phased manner, starting with regulatory reform of Indian legal profession before allowing foreign lawyers and firms to practice? What fees and requirements will foreign lawyers and law firms be subject to in order to register and practice in India? And are the eligibility criteria for registration of foreign law firms and lawyers under the BCI rules sufficient for ensuring national security, regulating the relationship with Indian professionals? And finally, what are the potential consequences of this decision on Indian legal service sector and the interests of Indian lawyers, particularly those who are socially disadvantaged and face discrimination in legal profession? Are the BCI rules discriminatory towards the Indian lawyers and firms, and do they create uneven playing field for Indian lawyers compared to foreign lawyers and firms? In conclusion, the Bar Council of India's decision to allow foreign lawyers and law firms to practice in non-litigious matters in India under certain conditions has received mixed reactions. Supporters argue that it will attract investment and aid in globalization of legal practice in India. However, the decision has also been met with opposition from Society of Indian Law Firms and All India Lawyers Association for Justice, who believe it will negatively impact the Indian legal profession. The Supreme Court of India has clarified the rules around the practice of law by foreign lawyers in India and established that they cannot practice in Indian law or appear before any Indian court, but can advise clients on their foreign legal matters temporarily.
Subscribe to our YouTube channel and click the bell icon.